A major new gun confiscation law just took effect, and what's happening right now should terrify every gun owner in America. This isn't another red flag law. This is something far worse, and it happened the moment the governor signed it into law. No waiting period, no warning, nothing. If you care about your Second Amendment rights, hit that subscribe button right now, because what I'm about to show you will change everything you thought you knew about gun confiscation. Let's get into it. When your rights disappear in an instant. On October 16th, the governor signed Assembly Bill 544B into law, and it became active immediately. What makes this different from every other gun law is the word mandatory. Law enforcement officers are now required by law to confiscate firearms when responding to any domestic incident call, regardless of whether anyone was arrested, charged, or even accused of a crime. The officer's personal judgment is the only thing standing between you and losing your firearms. According to data from the state police, officers respond to over 250,000 domestic incident calls every single year in the state alone. That's 685 calls every single day where firearms can now be seized without a warrant. The previous law from 2020 gave officers the option to temporarily remove firearms, but statistics show they only exercise that option in about 12% of cases. Now it's not optional anymore, it's mandatory in 100% of these calls, if the officer perceives any potential threat. The seizure happens without judicial oversight, without a hearing, and without you having any opportunity to defend yourself before your property is taken. Your concealed carry permit is also immediately suspended and confiscated on the spot. Within seconds of an officer making that determination, you go from a law-abiding gun owner to someone whose Second Amendment rights have been completely stripped away. Who has the power to disarm you? Anyone with a phone can now effectively disarm you without ever proving a single thing. National statistics show that approximately 18% of domestic disturbance calls are later determined to be false reports or misunderstandings. In a state that receives 685 domestic calls per day, that means roughly 123 people every single day could have their firearms seized based on false or mistaken reports. Your neighbor who heard you arguing with your spouse about what to have for dinner can call the police. A stranger walking past your house who sees you having a heated discussion about politics with a family member can make a report. An ex-partner who wants to cause problems can fabricate an incident. Even someone who simply doesn't like the fact that you own guns can claim they heard something concerning and make that call. The law doesn't require the caller to provide evidence. They don't have to give their name in many cases. They don't face any consequences if their report turns out to be completely false. Research from civil rights organizations shows that weapon confiscation laws without penalty provisions for false reporting see a 34% higher rate of frivolous complaints compared to states with accountability measures. This state has no such accountability measures in this new law. The cost of getting your guns back. The new law extends the confiscation period to 120 hours, 5 full days, representing a 150% increase from the previous 48-hour standard. But the real financial burden hits when you try to recover your property. Legal aid organizations report that gun owners spend an average of $2,200 in attorney fees, court costs, and administrative expenses just to initiate the return process. Some cases require multiple court appearances, pushing costs beyond $4,000. You're literally paying thousands of dollars to get back property that was taken without due process in the first place. State records show that approximately 30% of people whose firearms are seized under similar laws never recover them because they can't afford the legal costs or navigate the complex bureaucratic process required. The burden of proof falls entirely on you. You must provide documentation proving you're not a prohibited person, pass additional background checks at your own expense, and in some cases, appear before a judge to argue why your constitutional rights should be restored. processing times for these requests average 45 to 60 days, according to court administration data, meaning even after the 5-day hold expires, you could wait 2 months or more to get your firearms back. During this entire period, you're defenseless, even if you've done absolutely nothing wrong and were never charged with any crime. The judge-DREDD problem. Police officers are now simultaneously the responding party, the investigator, the judge, and the enforcement mechanism all in one. They arrive at a scene, make an immediate determination based on their perception, and execute the seizure without any external oversight. Constitutional law experts have pointed out that this creates what they call a single-point failure system, where one person's judgment, made in a high-stress, rapid response situation, determines whether you lose your constitutional rights. Studies on police decision-making show that officers make an average of 12 major decisions per shift, and research indicates that decision accuracy decreases by approximately 23% during high-stress calls compared to routine interactions. These are the conditions under which your Second Amendment rights are now being decided. Unlike red flag laws, which at least require someone to present evidence before a judge and obtain a court order, this system has zero judicial involvement at the point of seizure. Red flag laws, despite being constitutionally questionable themselves, still involve affidavits, hearings, and some form of due process, even if it's after the fact. Analysis of red flag law applications shows that judges deny approximately 15 to 20% of requests due to insufficient evidence. That judicial filter doesn't exist here. There's no one reviewing the officer's decision before your guns are taken. It's just an officer's feeling in the moment. The ripple effect across America. History shows us exactly what happens when one state passes extreme gun control measures. California passed magazine capacity restrictions in 2000, and within 10 years, 9 other states followed with similar laws. When one state banned certain semi-automatic rifles, 6 others passed nearly identical legislation within 3 years. Policy analysts have documented this pattern repeatedly. Anti-gun states watch each other closely and copy legislation that survives initial legal challenges. This confiscation law represents a blueprint that other states are absolutely watching right now. Governors and legislators in New Jersey, Illinois, Maryland, Massachusetts, Connecticut, Washington, Oregon, and Hawaii have all publicly stated their desire for stronger gun control measures. If this law stands, if it's not immediately challenged and struck down, you can expect to see versions of it introduced in state legislatures across the country within the next 6 to 12 months. The pattern is predictable and well documented. One state tests the legal waters with extreme legislation. If it survives the first few months without being blocked by courts, other states rush to implement their own versions. Before long, what seemed like an isolated incident in one state becomes the new normal across multiple states, affecting tens of millions of gun owners. Currently, approximately 95 million Americans live in states with Democratic governors and legislatures that have shown willingness to pass aggressive gun control. That's nearly 1/3 of the country that could potentially face similar confiscation schemes if this becomes the template. The constitutional collision course. This law doesn't just violate one constitutional amendment, it crashes directly into at least 3 separate constitutional protections. The Second Amendment's "shall not be infringed" language is obvious, but the Fourth Amendment's protection against unreasonable searches and seizures is equally violated when police take your property without a warrant. The Fifth Amendment guarantees that no person shall be deprived of property without due process of law, and the 14th Amendment extends that protection against state governments specifically. Legal scholars specializing in constitutional law have noted that laws violating multiple constitutional provisions simultaneously tend to face much faster judicial intervention and have a significantly higher overturn rate. In Supreme Court cases since 2010, laws challenged on multiple constitutional grounds have been struck down or significantly modified in approximately 68% of cases. The Bruin decision from 2022 fundamentally changed how courts must evaluate Second Amendment cases. Courts can no longer use interest-balancing tests or claim that public safety concerns justify infringement. They must now apply a text history and tradition analysis, asking whether the regulation is consistent with the nation's historical tradition of firearm regulation. Seizure of firearms without judicial warrants or due process has no historical precedent in American law. Colonial and founding-era laws, even at their most restrictive, required judicial proceedings before confiscating weapons. This law skips all of that, making it exactly the type of regulation that post-Bruin legal analysis should reject immediately. If you found this information critical, hit that subscribe button and turn on notifications so you don't miss updates on this law and others like it. Share this video with every gun owner you know, because what happens in one state will spread to others if we don't push back. Drop a comment below with your thoughts on this confiscation scheme. Thanks for watching and stay vigilant.